there with pre-knowledge from the attorneys in your research.
All right, Jamie, let's break this down a little bit here. So on cross-examination, there was a little bit of this wobbliness that was going on, but essentially what came out was that the defense attorneys decided, this is going to the ineffective assistance of counsel argument, that basically people were telling them that it looks like the case is going well and that the defendant is going to be acquitted. And they obviously did not call that witness. And those lawyers are apparently going to be called as witnesses as well. My anticipation of this is going to be as follows, and I'm shooting your thoughts, that they may have crossed the state's expert well. They felt like the state didn't prove a lot of its case, which a lot of people that watched this trial opined they did not. And they didn't want to dumb it up or gum it up, if you will, by putting an expert on that could be subject to cross-examination, giving the state an advantage in somehow. They didn't want to mess that up. And maybe with this note situation, that made it more complex for them and pushed them to the point of saying, maybe we don't, when you stand well, stand still. That's a phrase we use. What do you think here? Because this is basically the witness saying they were confident in their case.
You know, those are some fair assumptions, Bob. My concern would be that there appears to be in the record that these allegations of internet searches have been dogged and discredited to some degree. At least that's my understanding of the record. So, you know, if that's the case, to take a risk that these particular notations that we've talked about, maybe there's others in the notes, are somehow going to, you know, the risk of having those in there are going to be outweighed, you know, versus the extraordinary testimony of Dr. Diamond and how he can explain these memory lapses, I think was probably bad strategy. But there's a more important issue that I think is going to come out when we deal with Dr. Diamond's testimony or lack thereof at trial. You know, the appellate attorneys are trying to have it both ways. You know, they're trying to argue that Dr. Diamond was so important that we could have potentially had a different outcome. At the same time, they're arguing an ineffective assistance of counsel for not calling him with these other issues out there. And of all of the arguments that are contained in this brief, this one is huge, but I think it's going to probably be the least effective when they get to the appellate courts, presuming judge doesn't do anything at the trial level, because, you know, every single time we see an effective assistance charge in a case like this where counsel makes a decision, the courts are pretty consistent in their findings. And that is that, you know, unless you can show me that it wasn't trial strategy, we're not going to rule that the decisions made by counsel was ineffective. And that's why I think at the end of the day, this argument is going to be circular. It is circular. And I think the Court of Appeals is going to probably fall back and say we're going to rely.
Yeah, Jamie, I agree with that. Tactical decisions are very rarely reversed, except for the most egregious of them. Guys, we got to take a quick break. We'll be back on the other side. Stay with us.